He preferred criminal appeal number 3338 of 2018 before the High Court of Telangana.
11 Weekly, page 55. So live.
The High Court also thought fit to dismiss the appeal. However, the following has been noted by the High Court in para 11 of the impugned judgment. Put this para 11 at page 11. Right? The High Court. We have heard Mr. So-and-so, the learned counsel, appearing for the petitioner. He submitted that the petitioner has undergone almost 12 years of sentence so far. The leave granted. Having regard to what has been observed aforesaid, we suspend the substantive order of sentence of life imprisonment as imposed by the trial court and affirmed by the High Court, an order that the appellant be released on bail pending the final disposal of this appeal, subject to terms and conditions that the trial court may deem fit to impose. Next matter.
Grateful for that.
Yes.
Your Lordship, this is regarding the quashing of FIR along with the final report that is submitted by the police, Your Lordship. The issue here was, Your Lordship, there were allegations of 498A and other allegations, Your Lordship.
So sister-in-law quashed.
They say 5 minutes by the sea can make you come alive.
Sister-in-law quashed.
Yes, Your Lordship.
Husband has to face the music.
Yes, Your Lordship.
And what is that criminal case number? Criminal case number?
Of the criminal case number.
Well, give us the criminal case number, na?
FIR.
Oh Lord.
Just a second.
Yeah.
Page 80.
Charge sheet filed. Na?
Yes, Your Lordship.
So once the charge sheet is filed,
Yes, Your Lordship.
and the magistrate takes cognizance,
Yes, sir.
it culminates in some criminal case number, right?
Yes.
What is that criminal case number?
Number I'll have to check.
You don't know?
I don't have the number, Your Lordship. I have the charge sheet and final reports, Your Lordship. But I'm really sorry, Your Lordship.
Well, why should you be sorry? Your client should be sorry. You don't know the criminal case number. Without the criminal case number, how are we going to grant the relief?
Kindly just pass over, Your Lordship. I'll get it. If
Issue notice. In the meantime, the further proceedings of criminal case number so-and-so, pending in the court of so-and-so, shall remain stayed.
much obliged, Your Lordship.
It's 1:15.
I'll get in 5 minutes, Your Lordship.
अगर 5 मिनट में नहीं आए तो फिर रिलीफ नहीं है.
Much obliged.
You open the matter. Open the matter.
Yes, Lordship, this is item number 20, which is on behalf of the Legal Services Committee. This is against the confirmation of conviction and sentence by the High Court for the offence under section 307 of IPC. And the punishment which has been granted is the maximum punishment available under 307. So, Lordship, I am only on.
It has undergone how much?
5 years of sentence, Lordship.
लिखिए. Leave granted. having regard to the nature of the evidence on record, we suspend the substantive order of sentence of life imprisonment imposed by the trial court and affirmed by the High Court, and order that the appellant be released on bail forthwith, if not required in any other case, on the terms and conditions that the trial court may deem fit to impose. Anything else, ma'am?
No, Your Lordship, I'm much obliged. I'm really obliged, Your Lordship. Legal services matters are really hard, so I'm much obliged.
You should have grabbed the opportunity. You allowed your senior to appear. That's why we told you, argue, open the matter. Right?
Lordship, I had a very bad throat, so that is why I requested her. It
But
is
she
too
has
bad.
a very good throat. I could have argued. Acha, 4121 days delay. You appear.
Yes, Your Lordship. Lordship, the delay is 324 days.
I'm not talking about you, ma'am. You leave,
I'm
your
sorry.
matter is over.
Yes.
Yes, my lord. It's legal services committee matter. my lord.
4121,
He is in judicial custody for more than 19 years, my lord.
19 years.
19
What is
years.
the offense?
302,
Oh.
376, my lord. It's based on circumstantial evidence.
This is a legal aid matter.
Yes, my lord.
There is a delay of 4121 days in filing the special leave petition. However, having regard to the fact that the petitioner is undergoing life imprisonment past 19 years, we condone the delay. Leave granted, same order that bail order, released on bail. Correct?
Obliged, highly obliged.
Please, Lord. Lordship, in this case, the petitioner who was a complainant was of 3 FIR has been impleaded as the while exercise of power under section 319 by the trial court on finding a prima facie case on the basis of the evidence of a scientific expert, Lordship. Lordship, actually, there were 5 FIRs. There were 5 FIRs lodged by 3 patwaris, one by the petitioner who has lost 3 FIRs, and 2 other patwaris have lost 2 other FIRs. In all the matters, the trial court has exercised its power under section 319.
Issue notice. In the meantime, the impugned order summoning the petitioner as accused in exercise of powers under section 319 of the CRPC shall remain stayed from its operation.
Yes.
Next matter.
Lordship, petitioner may not be arrested because
Because
You, Mr. Luthra, you better take some tuitions at the end of the day. You are an expert in this subject. You enlighten the bar. These queries are not next matter. So,
Lordship, there is some delay, Lordship, 10-14 days.
okay, condone.
Much obliged. I'm sorry.
23, my lord. Yes, my lord. The trial court convicted all the 3 accused. Under the 302.
Share your expertise with the bar. Share your expertise.
I'm more than happy to do that.
What is this?
Yes, my lord. Trial court, my lord, they convicted all the 3 accused, my lord. Honorable High Court acquitted 2 and convicted 1 under 307, not 302, my lord.
And sentenced to undergo?
Sentence he has already 11 years and 2 months like
So
that.
then why are you here?
My lord, he came against that, my lord, the conviction against. Okay, he is also not, my lord,
Huh?
against the conviction, my lord.
32 days delay.
There's a delay of 500
Because yeah, my
Your
lord,
conviction was altered from 302 to
my lord, he came
307. You have undergone the entire sentence.
Yes, my lord,
Are
yes.
you a public servant?
No, my lord.
Nothing, dismissed. Next matter.
Hey, people.
24 minutes, I was on section 12 minutes not convicted under POCSO. Minutes 354C maximum sentence minutes. And please see minutes the evidence and minutes the entire with respect minutes the impugn judgment minutes. It is minutes victim centric minutes everywhere it is said victim minutes. Where is the minutes the legal rights of the accused? Number one.
You were serving as a domestic help
Yes,
in the house.
yes, minutes.
Victim was a minor.
Yes, minutes.
She was in one room. She was
That's their
changing.
minutes. That's their minutes.
You were peeping in the room, and then you took video while she was changing, and then
Minutes, I
you
only
were
sentence
caught
part.
red-handed. Mobile recovered, sent to FSL. Video has been found. How do we help you?
I'm only requesting minutes to consider on sentence part. That's all minutes. 354C minutes maximum. That's all minutes. If your lordship can consider minutes, because I was 21 at that time minutes. I have reformed. Now minutes 5
What is the sentence imposed?
minutes under 354C maximum 3 years minutes.
Just a minute.
And minutes I have undergone minutes more than. I'm so sorry minutes. I'm so sorry.
354C, 3 years.
3 years minutes. Yes.
And what is the other offense?
Minutes the other offense is minutes 509 and minutes 12. But minutes under section 42 minutes POCSO minutes the court minutes considered convicting me under 354C
Right.
maximum 3 years.
And what about section 12?
Yes, minutes. But alternatively the sentence is under 354 because of 42 minutes.
And you are in jail today?
Yes, minutes more than 1 year, little more than 1 year.
1 year.
Yes. So only minutes.
So you
sentence.
should complete the sentence
Minutes,
for the
once, minutes, please consider one.
very
Minutes, just one request, minutes, beseech me. Minutes, lordship may consider minutes a poor chap, minutes.
he may be a poor
Yes,
chap,
and
but the crime
minutes-
committed is very.
Minutes, I understand. Minutes, all these 5 years, minutes, he has minutes reformed now. A first time offender, minutes. If my lords may consider on limited on the minutes extent to the extent of minutes, this sentence part.
Minimum prescribed sentence,
Minutes in 354C, minutes minimum is 1 year.
and you have undergone 1 year.
Yes, minutes, I have.
I am not convinced, but my brother is convinced. So you are getting benefit.
Because the client will get some Diwali, minutes, you know.
Diwali for such a man?
Minutes. Now, minutes, he is mad.
It's all right.
I'm so sorry.
It's all right. But we'll have to hear the other side now.
Let's consider granting bail, minutes, that's all, minutes, and not to issue notice.
Correct. But he will be released only after.
Yes, yes,
Diwali.
no difficulty.
Only after
Minutes,
Diwali.
no difficulty, minutes, no difficulty, minutes. Lordship may issue notice on bail also. Not say it. My lords have considered so minutes. I requested if your lordship can consider granting bail, minutes, interim bail, minutes.
The petitioner was put to trial. In the court of the additional sessions judge -05 bracket POCSO North District Rohini Courts, Delhi, in connection with sessions case number. What is that sessions case?
228 of 2018, minutes.
228 of 2018 arising out of FIR bearing number 115 of 2018 registered at police station Mukherjee Nagar for offences punishable under sections 354 capital C and 509 of the Indian Penal Code and section 12 of the Protection of Children from Sexual Offences Act 2012 for short POCSO. Next. The appeal filed by the petitioner herein before the High Court also failed. in such circumstances referred to above, he is here before this court with the present petition. We take notice of the fact that the incident is of the year 2018. At the relevant point of time, the petitioner was 21 years of age. So far as section 354 capital C of the IPC is concerned, the minimum sentence provided is 1 year. 1 year. Full.
Maximum 3 years.
And the maximum is 1 year, which may be extended up to 3 years. Full point. Having regard to the fact that the petitioner is undergoing sentence past 1 year and the maximum sentence is of 3 years, we may consider reducing the sentence after hearing the state. Full point. Issue notice. In the meantime, the petitioner is ordered to be released on bail, subject to terms and conditions as may be imposed by the trial. Okay, sir? Yes.
25.
Wait, please, Your Lord. For almost 10 years, 9 years and 10 months, my lords. Out
What
of
is
the
the
eight
offense?
accused,
What?
my lords, offense under 147, 148, 302 and 2527 of the Armed
10
Act, my
years.
lords.
10 years.
He's been 9 years and 10 months as on today, my lords.
Any
With four of
antecedents?
No, my lords. As far as there is a the custody certificate is at page 110, my lords.
Yes.
Of sentence.
Yes, my lords.
Before the High Court.
Yes, and bail, my lords. Suspension of sentence and bail. Out of the 8 accused, my lords, 4 were enlarged on bail. 4 were not given on the ground that they had a role in firing. The others had carried lathis. So only no extenuating circumstances, only the roles, my lords.
Your appeal is of 2022.
Yes, my lords, unlikely to be heard in any.
Blessings from Bali. I'm at a serene boho chic cafe and it's beautiful here. Dream catchers reflect such.
It is of 14.
Yes, my lords, 2/11/14.
It's a case of double murder.
My lords, the second victim died 3 years after the incident, my lord. But
Because of the injuries?
it could be attributed to
3 days? 3 years?
3 years.
3 years?
Yes, my lord, 3 years.
What was the nature of the injury?
Bullet injury.
Bullet injury. How many are before us?
Only one.
What is the role attributed to
But
this?
there are,
Five.
with respect to 4 of them are said to have borne firearms, and those are the 4 people who have been denied bail by the High Court, my lords.
The petitioner is undergoing life imprisonment for the offence punishable under section 302 of the IPC. He is undergoing sentence past almost 10 years. His appeal of the year 2022 against the judgment and order of conviction passed by the trial court is pending before the High Court of Allahabad. Full point. Having regard to the fact that the appeal is of the year 2022 and there is no likelihood of the appeal being heard in near future, क्या लिखा आपने? Of the appeal being taken up in near future, we are of the view that the substantive order of sentence of life imprisonment deserves to be suspended. till the final disposal of this appeal. Till the final disposal of the appeal pending before the High Court. Good point. Next. The petitioner, but we'll have to hear the other side. अच्छा ये निकाल दो. Issue notice. Having regard to the fact that the petitioner is undergoing life imprisonment past more than 10 years, he is ordered to be released on bail, subject to terms and conditions as may be imposed by the trial court. So, okay.
Obliged.
26. Say NDP matters was commercial quantity, my lords. The bail has been granted by Karnataka High Court, my lords.
You want us to cancel the bail?
My lords, we are on the point, my lords, that the quantity here, my lords, that alprazolam tablets are 1,000.
What is the ground on which the High Court has released him on?
Well, that the quantitative taste is not there. The tablet may contain impurity, my lords. The total weight may not be commercial.
Next matter, delay congress.
27. The question of law may be kept over.
What question of law?
Because there are the judgment for 2020 which says, my lords, that it is to be taken into consideration along with the...
Doesn't matter.
Law.
Next. Yes.
27.
My lords, if I may. My lords, this is a matter which is between a husband and a wife.
Right.
And the whole matter is revolving around the fact that the wife is belonging to an affluent family. And unfortunately or fortunately, she's been married to the petitioner. And now she has to live either as Vitnagari or for a small time of within the year, she might have to go to the village which is situated in Sagar, Madhya Pradesh. Now, my lords,
What is the criminal case number?
Criminal case number, my lords. 1731.
Which court?
My lords, High Court of Honorable High Court of Madhya Pradesh. Sorry?
Your clients will be put to trial in a particular court.
My lords.
Which is that court?
My lords, that would be JMFC, Khandwa.
Khandwa. Where is this Khandwa?
My lords, in the state of Madhya Pradesh.
What is the criminal case number?
It says, my lords, RCT number 1719 of 2022.
What is this RCT number?
And the FIR number in crime number, that's 12.
What is RCT number?
Regular criminal complaint, my lords.
Yes. What is RCT?
I think that it pertains to the domestic violence case, that a criminal complaint.
Because, my lords, it's IPC read with the Dowry Act as well.
Or see.
Notice. In the meantime, the further proceedings of RCT number so-and-so arising from FIR number so-and-so pending in the court of so-and-so shall remain stay. Yes.
28.
My lords, this is a family of 6 people, my lords, and I'm seeking protection, my lords. They have come from Bareilly, staying in Delhi from past 4 months, my lords.
What type of protection?
My lords, we are regularly receiving calls and there is an apprehension, there may be an attack on us and there may be threat to our lives, my lords. I've left my home, or my entire family and I, my wife, my young daughter, her husband, and my sons. 2 of them are minor and 1 is young, my lord.
But who is calling you up?
My lords, we are receiving calls from police personnel also, and we are receiving calls from some unknown phone numbers as well, my lords.
For what?
My lords,
What have you done?
I have made complaints, my lords. I've also made a complaint here.
Complaints against whom?
My lords, what had happened was, my lords, that my son, who's a minor, he was forced into marriage with one of the neighbor's daughter, who's also a minor. To which
Why have you invoked 32?
My lords,
have gone to the
my lords, the difficulty is this. I've been receiving calls from UP. There's a threat from the police there. I am here in this jurisdiction.
Okay, we believe you that you are being threatened. But what is so special that you have invoked the jurisdiction of this court under Article 32? You could have preferred a petition under Article 226 before the High Court of Delhi.
My lords, I bow down to that.
Delhi, na?
My lords, the only difficulty is I am a resident of UP who has come down to Delhi. My lords, the jurisdiction of the Delhi High Court is limited to the territorial jurisdiction of this state. My home is in Bareilly. If I have to go back...
You may be a resident of Bareilly,
yes,
but if you are at present in Delhi,
yes, my lord.
If the threats are being administered to you in Delhi, your life is in danger while being in Delhi, and the authorities who are threatening you are also in Delhi,
and in
then why High Court of Delhi will have...
That's because I'm also getting calls from state of UP, the police personnel is there, and I have to go back. I'm a family. State of UP is a necessary party, my lords.
Not convinced with the matter which you have projected before us.
My lords, it involves the jurisdiction of 2 states, and therefore I have come before my lords. Had it been confined only to Delhi or either UP, my lords, I would have not come before my lords.
And you just see the relief, issue a writ of mandamus, any appropriate writ, order or direction to the respondents to ensure the safety, liberty and protection of the petitioners, and not to take any coercive action against them or for other directions. Blanket, absolutely omnibus.
My lords, I'll confine my relief. Only the family members. It's a family of 6.
Why are y'all being chased? Convince us now. What is a good reason?
My lords,
why are y'all being harassed?
My lords, we are being harassed. What happened? My neighbor's minor daughter, they wanted her to get married to my minor son, who is also a party here before my lords, to which I refused. I had to leave my entire family leave from there with my entire family and come to Delhi. 4 months I have been here, just because I refused to marry my minor son. That's the only reason.
You approach Delhi High Court, you file a petition there.
My lords, even if I do that...
Having heard the learned counsel appearing for the petitioners, and having gone through the materials on record, we are of the view that the petitioners should invoke the jurisdiction of the High Court of Delhi under Article 226 of the Constitution and seek appropriate relief. Full point. We clarified that we have otherwise not gone into the merits of the matter. We are of the view that the petitioners could not have invoked the jurisdiction of this court under Article 32 of the Constitution. Next matter.
Deeply obliged.
29.
So I'm appearing for the respondent for court stated.
Your Lordship, I appear for the petitioners. The main counsel is on his legs before the Honorable High Court. May kindly grant a passover.
No passover today, ma'am. What is this matter?
This is the same matter for grant of sanction, Millards, flowing from Shankaran Moitra's judgment, Millards. It was heard on the last occasion. Respondent number 1 wasn't present, Millards. I believe
I'm appearing virtually. I'm unwell, so I'm appearing virtually, Your Lordship. I sincere apologies for not being there on the last day.
Who is he? Who is he?
Millards, he's the complainant. For the complainant, Millards.
Nee.
Petitioners accused, Millards.
They are police officers.
Police officials, Millards.
Okay. And Mr. Mukherjee appears for
the
de facto complainant.
Fine. And what was this revision application before the High Court?
Millards, it was regarding the grant of bailable warrants, Millards, by the lower court. Against that, the complainant had come to the High Court, Millards.
For what? For getting the bailable warrants?
Executed. The complainant had come, Millards.
Okay, complainant came.
Millards.
So there are warrants issued against the
police officials, Millards.
And they are not being executed.
Millards.
So what did the High Court do?
Millards, in the meanwhile, considering the fact that there was a government notification, Millards, regarding applicability of Section 197 which required prior sanction for prosecution against police officials, my lords. The High Court applies that.
Allegations basically.
Because the allegation was on the day of polling, my lords, the husband of the complainant, my lords, was injured in a mob attack because there was a conflict between two political parties. The story of the prosecution is that.
What is the story against the police officials?
Because the story of the version of the complainant is that the three police officials who were the accused, my lords, including the ACP who's now been discharged because of want of prosecution, my lords, they got hold of him and they beat him to death. That's the story of the complainant. Whereas, my lords, there's a parallel version which states that, my lords, there was a conflict between two political parties at the polling booth. By the time the police arrived, my lords, there was a bomb explosion. Some people jumped into the nearby pond to evade that pond.
And there they got drowned.
He got injured, my lords. He hit his head to the curb of the pond. That's what the FSL also says, my lords.
Our argument is that in the absence of any valid sanction, they cannot be prosecuted. They cannot be put to trial.
Yes, please.
Right? That's and you are supporting the.
Because we have denied the sanction for prosecution.
Right.
There was a subsequent notification. Was initially
Now the trial court has summoned them.
My lords.
Correct?
Because the trial court has summoned them, my lords. Against that, my lords, against one summons, my lords, they came to the High Court for quashing, which was quashed. There was a prior order of summoning as well. They went. The complainant went to the learned CJM saying that at least that warrant order has to be executed. The CJM said nothing doing because now there is an order of the government saying that 197 prosecution also applies to inspector and lower ranks, my lords. Against that, the complainant went to the revision court, my lord, the High Court, and the High Court, my lord, said that since the government order of the state extending 197 to the officers of the rank of inspector and below is not retrospectively applicable, therefore the petitioners.
Ms. Sharma.
Yes.
हम मूंगफली बेचते हैं
Under 197 as raised by the complainant. Correct?
We are supporting the case of the petitioners.
Even in the absence of sanction, trial court can say that for the present I am taking cognizance. In the midst of the trial also, if I find that no sanction is required, I can stop the trial and ask if you obtain the sanction. Now, what has the complainant done so far as state declining to grant sanction?
Nothing else.
Complainant has not taken any steps.
Prosecution denial has not been challenged by the complainant.
So now, there are two petitioners before us, right?
My lords.
They both are now sought to be prosecuted for the offence punishable under?
My lords, under section 302, my lords. Under 148, 149.
Who was Shankaran Moitra, their superior?
Yes, my lords. He was the ACP Eastern Division at that point in time, my lords. Since
these two officers were a part of the team that was led by Moitra.
My lords, petitioner number 1 was the officer in charge of the police station.
Allegations against one are at par with these two?
My lords.
Yes, Mr. Mukherjee, what do you have to say? 2 minutes.
Your Lordship, I have been suffering for the last 12 years. Your Lordship, my husband died.
Come to the point, the neat question of law is raised.
My Lord, it cannot be retrospective in.
Okay, chalo.
According to me.
For the time being, we proceed on the footing that this notification cannot be applied with retrospective effect.
Absolutely, Your Lordship.
Tell us, how will it not attract 197?
My Lord, 197 clearly lays down the rules by which a person can be prosecuted, a government servant can be prosecuted.
You tell us why the judgment in Shankaran Moitra will not come to their rescue.
My lord, the judgment in Shankaran Maitra was at a time when the notification by the state of West Bengal was not there.
Forget about that notification. Okay, Acha, your argument is that 197 on the face of it was not happening.
Yes.
Were not
Okay.
to the rank of inspector.
The superior who was covered in your notification got the benefit. These people were subordinates, same set of allegations. They are sought to be put to trial. Arguments concluded, judgment reserved. Will you all do one thing? Will you all give some
We had on the last date of occasion given a list of dates because I'm carrying extra copies.
submissions?
Because
The form of
dates were those we prepared submissions of Milods may.
Okay. The learned counsel appearing for the respective parties shall submit their written submissions by 4th of November 2024.
Grateful.
Just one thing, whether here the cognizance was taken before the notification or after?
Before the notification, Milods. Any procedural notification has to be retrospectively, irrespective whether it mentions or not, Milods.
Item 30.
Lord, other side is submitted letter. They want to file. Lord, I appear for the respond number 1, my lord. I wish to file counter in this.
After 4 weeks.
Great oblige, Lord.
31.
This comes to your lordships after notice. There are two aspects. One is, my lords, my application which is listed. One is a procedural aspect which we need to, my lords, I need to point out. I have filed an application for implement of Kotak, which is the bank, my lords, to whom the loan has been assigned by PNB. Now the background is this. The entire money was disbursed by PNB, my lords, directly to Unitech in one go. I obtained a decree, my lords, from the NCDRC, where the NCDRC directed Unitech, my lords, to refund the money to the developer, the bank, PNB.
Yeah, keep it afterwards.
Very well.
We have not seen the matter.
No problem. This application may be allowed, my lords, of implement of Kotak, my lords, because the loan is now assigned.
Any objection?
Well, that is, and I appear for R1, which is Unitech. Let's in fact, my lords, the series of that matter, that's before Honorable Court one, the
implement application allow kar dijiye, koi baat.
Lordship.
Yes.
Oblige.
What is this?
Plot 33. But this is a situation not where the High Court in the exercise jurisdiction under latest patents appeal in a 220 arising out of a 227 matter, and thereafter passes directions in relation to an investigation which is not in its season. So this is the issue not we are here for. And I must just point out, Lord.
Who are you?
But I am the person, Lord, who is running a school there right now, Lord. There was land which was allotted to certain people.
So what have you done?
Lord, I bought the land and I'm running an institution there.
Hey, why 406, 409?
Lord, I'll tell you, Lord, that's against the original allottees, Lord, because they say that the allotment to the original allottees was bad.
So what is the case against you?
I'm sorry, Lord?
What is the case against you?
I'll tell you, Lordship, Lord. Lord, what happened was, there is a land which is not people who were displaced persons, Lord, they were entitled to get land.
Charge sheet is filed?
Lord, charge sheet is not yet filed. Charge sheet is not yet filed. Lord, this is in a civil. This is a civil matter. This is a civil.
Who has stated?
This Honorable Court has passed an order of status quo.
Is at the stage of notice.
Status quo. No, Lord, status quo.
Status quo is that now since 2018 there is a status quo.
Yes.
Mr. Luthra.
Yes.
If you are protected, we'll take it up after.
There is a difficulty, madam. We have moved an application for clarification of that order.
whereby the status quo has been passed.
What clarification?
Charge sheet has not been accepted by the trial court, my lords. Since 2020, we are ready with the charge sheet, but because of the order of this honorable court, my lords, they have not assailed that criminal side of the aspect.
Then what have they assailed?
They have assailed. There are two findings in this impugn order, my lords. One is pertaining to the land. That land has been reverted back to the government, my lords, and immediate possession has been said to be taken by the government. Second is that re-investigation should be done. Now, pursuant to that re-investigation, my lords, we are ready with the charge sheet.
Who prayed for re-investigation?
Suo moto, the court passed that order, my lords.
Acha, okay. Under 173A?
No, Honorable High Court passed the order under the LPA jurisdiction.
And what happened after that order of re-investigation?
Now, the charge sheet is ready, my lords, but the court is not accepting because there is a status quo order by this honorable court.
We'll see. We'll take a call.
Grateful. A short date, my lords, if I'm asked. I'll leave it.
34.
Grateful.
So on 27th September, Lordships had asked for some constructive responses of both the examination board as well as the central government. Lordships had also requested the additional Solicitor General to assist. Now, Your Lordships, we have been given this short affidavit which has been filed by the Under Secretary Ministry of Health. And most characteristically, basically the ball is being shuttled between the authorities. And what we are praying for, Your Lordships, is that in NEET-PG, Your Lordships, the information memorandum is not published. And there is no SOP how the examination has to be conducted. And Your Lordships will kindly also take note of the fact that several states have also not been able to continue with their counseling.
Answer key was published or not?
Your Lordships, as far as the answer keys published concerned, I don't think they've published it.
Because I appear for
And
National Board of Examinations.
They were not published.
No, no, my lords. We had specifically stated so in our information bulletin that answer sheets will not be given. The reason being, my lords, these are super specialty exams at the post-graduation level. And my lords, the
Not objective type.
questions are very limited, my lords.
Are they objective type or not?
Yes, my lords. Objective and very limited at that stage. Appropriate difficulty level questions are so limited. And my lords, if we start giving questions and the answer sheets every year, within 3 years, all our questions will go. And then, my lords, it will become very difficult for us to.
My lords, I'm appearing in 34 and 34.1, my lords.
Curve marks and
My lords, one petition is for this year.
This year.
One petition is for the counselling for this year, which is 34.3 before your lordships. All other petitions starting from 34, 34.1, 34.2 are for the earlier years.
because the procedure from the past years. One second, I'll just clarify, because the procedure from past years has not been transparent. So this issue comes up.
You have been able to examine your answer sheets under the RTI Act.
Your Lordships have not given. In fact, there is.
So did you apply under the RTI Act?
Because these are this is a complete because there are no answer sheets that way. Because there are objective type questions and computer based, and the checking is also done by the computer.
Online. There is no like there is no
human element involved.
There is a bar for me asking it. In fact, there is a penal consequence.
That's a
for
precondition.
asking. So this issue of transparency has been existing for the last 2 years, which your Lordships are.
There is, Milord, there are judgments on that also. Milord, we are covered by it.
We'll have to hear this.
Yes, your Lordships. May I, in the meanwhile, request your Lordships
to appear online, my lords, for 34 and 34.1.
Yes, yes.
My lords, we have filed, in fact, a detailed syllabus to show that how the argument that the questions are limited.
Notify this matter on any NMD day for final disposal.
Please.
Meetings are completed.
Please, your
Lordships, they're complete, but I would say they are not to the satisfaction because they have to give some constructive input.
We have filed a very detailed report.
We can give those suggestions, we can circulate.
Plus, Union of India has not filed a very detailed reply, but we filed.
You all keep your notes ready.
Very well.
Please,
In all aspects.
Very well.
We'll hear you all for some time.
Very well.
And then we'll see what best we can.
But Union of India's presence would be masked, Milos. They are not present today also. Because Milos, counselling, etc. is done by them. We are only exam holding body.
Union of India is sitting right now.
I'm just telling my girlfriend, I hope I don't get dragged. Yes, I.
Will you take notice?
Yes, I'm pleased.
Is someone appearing for?
Lordships have already filed a reply.
Yes, Milos.
So they are appearing, they probably may not be here today.
So we don't want to duplicate requests. If there's a
Lordships had requested the learned ASD to.
Whoever is appearing.
Yes, Your Lordship.
Just speak to your colleague that we'll take it up on the next date.
Okay.
Maybe request for.
He will, my court master.
Very good.
35.
Lordship.
That's 35 minutes.
Lordship, this is a contempt matter.
Because there is no interim order on.
Lordship, repeated undertakings by the law officer.
One at a time.
I'll make a submission. Because there are a number of contempt petitions saying that the order has not been complied with.
Which order? Which order?
Well, this is the order of the report.
These are contempt proceedings.
Lordship, contempt proceedings and
against the Union of India.
Yes.
Against the Union
on the
of
ground,
India.
On the ground.
Undertaking